4 Lesson 1 Introduction to Company Law. Lesson Outline. Introduction. History and Development of Company Law in India. The Companies Act, 1956. O Concept Paper on Company Law, 2004. J. Rani Report. O Companies Bill, 2012. O Companies Act, 2013. Meaning and definition of company, nature and characteristics of a company, company vis-a-vis other forms of business, doctrine of lifting of or piercing the corporate veil, applicability of Companies Act, 2013 and key concepts, lesson roundup, glossary, self-test questions, learning objectives. The concept of company or corporation in business is not new, but was dealt with in 4th century BC itself, at the time of Arthashastra. It has evolved over time according to the needs of society and business dynamics. The word company is made of 2 Latin words, com, meaning coming together, and panis, meaning bread. Company originally referred to group of people who took their meal together. It is important for the students as future company secretaries to understand the concept and legal provisions of company law very well, as this forms as major part of working in future, whether in practice or employment. This chapter introduces the reader with the background and evolution of corporate legislation in India, the distinct features of company, other forms of business, concepts under new law, etc. Introduction. Jurisprudence of company law. Company law in India is the cherished child of the English parents. Our various Companies Acts have been modelled on the English Acts, following the enactment of the Joint Stock Companies Act, 1844 in England. The first Companies Act was passed in India in 1850. It provided for the registration of the companies and transferability of shares. The amending Act of 1857 conferred the right of registration with, or without limited liability. Subsequently, this right was granted to banking and insurance companies by an Act of 1860 following the similar principle in Britain. The Companies Act of 1856 repealed all the previous acts. This act covered aspects of incorporation, regulation and winding up of companies and other associations. This act was recast in 1882, embodying the amendments which were made in the company law in England up to that time. In 1913 a Consolidating Act was passed, and major amendments were made to the Consolidated Act in 1936. In the meantime, England passed a Comprehensive Companies Act in 1948. In 1951, the Indian government promulgated the Indian Companies Amendment Ordinance, under which the central government and the court assumed extensive powers to intervene directly in the affairs of the company and to take necessary action in the interest of the company. The ordinance was replaced by an amending Act of 1951. History and development of the concept of company law in India. The Companies Act, 1956, based on Baba Committee recommendations at the end of 1950, the Government of Independent India appointed a committee under the chairmanship of H.R.C. Baba to go into the entire question of the revision of the Indian Companies Act, with particular reference to its bearing on the development of Indian trade and industry. This committee examined a large number of witnesses in different parts of the country and submitted its report in March 1952, based largely on the recommendations of the Company Law Committee. A bill to enact the present legislation, namely, the Companies Act, 1956, was introduced in Parliament. This act, once again, largely followed the English Companies Act, 1948. The Companies Act, 1956 was enacted with a view to consolidate and amend the earlier laws relating to companies and certain other associations. The act came into force on 1 April, 1956. This Companies Act was based largely on the recommendations of the Baba Committee. This act was the longest piece of legislation ever passed by our Parliament. Amendments have been made in this act periodically. The Companies Act 1956 consisted of 658 sections and 15 schedules. Full and fair disclosure of various matters in prospectus, detailed information of the financial affairs of company to be disclosed in its account, provision for intervention and investigation by the government into the affairs of a company, restrictions on the powers of managerial personnel, enforcement of proper performance of their duties by company management, and protection of minority shareholders were some of the main features of the Companies Act, 1956. The Companies Act, 1956 was enacted with the object to amend and consolidate the law relating to companies. This act provided the legal framework for corporate entities in India, and was a mammoth legislation. As the corporate sector grew in numbers and size of operations, the need for streamlining this act was felt, and as many as 24 amendments had taken place since then. The Companies Act, 1956 had undergone changes by amendments in 1960, 1962, 1963, 1964, 1965, 1966, 1967, 1969, 1971, 1977, 1985, 1988, 1996, 1999, 2000, 2002 and 2006. The provisions of Companies, Second Amendment, Act, 2002 were not enforced except that of definitions and the Constitution of NCLT, National Company Law Tribunal. The Companies Act, 1956, was also amended pursuant to the enactment of the Depositories Act, 1996. Unsuccessful attempts were made in 1993 and 1997 to replace the present act with a new law. Companies Amendment Bill 2003, containing important provisions relating to corporate governance and aimed at achieving competitive advantage, was also introduced. Brief of major amendments to Companies Act, 1956. Amendment particulars. The Companies Amendment Act 1960, based on the recommendations of Shastri Committee, this introduced several new provisions relating to various aspects of company management which were overlooked in the 1956 Act. The Companies Amendment Act 1963. This provided for the appointment of a Companies Tribunal and constitution of the Board of Company Law Administration. It also empowered the central government to remove managerial personnel involved in cases of fraud, etc. The Companies Amendment Act 1965, based on the recommendations of the Vivian Bose Commission, this introduced some major changes, such as clear definition of the main and subsidiary objects of a company in its Memorandum of Association, strengthening the provisions relating to investigation into the affairs of the company, etc. The Companies Act was further amended twice in 1966. The Companies Amendment Act 1969. Two important changes were introduced through this. The institutions of managing agents and secretaries and treasurers were abolished with effect from the 3rd of April 1970. Secondly, contributions by companies to any political party or for any political purpose were prohibited. The Companies Amendment Act 1974. This introduced some important and major changes in the Companies Act 1956. The object of the Amendment Act was to inject an element of public interest in the working of the corporate sector. The Companies Amendment Act of 1977. This brought about certain changes in sections 58A, 220, 293, 620 and 634A of 1956 Act. The Companies Amendment Act 1985. The amending act substituted section 293A of Companies Act 1956 with a new section permitting non-government companies to make political contributions, directly or indirectly, with a view that legitimate dues of workers rank pari passu with secured creditors in the event of closure of the company and rank above even the dues to government. Sections 529 and 530 of the Companies Act 1956 were amended and a new section 529A was introduced. The Companies Amendment Act 1988, based on the recommendations made by the Expert Committee, Sachar Committee, the Companies Amendment Act 1988 substantially amended the Companies Act 1956 in order to streamline some of the existing provisions of the Companies Act 1956 and to ensure better working and administration of the Act. The important changes introduced by the Amendment Act of 1988 were definition secretary in the of secretary brought in line with the Company Secretaries Act 1980, the definition of company and includes an individual possessing the prescribed qualifications. B. The concept of company secretary in practice was introduced for the first time in the Companies Act. The amended Act, among other things, also set up an independent company law board to exercise such judicial and quasi-judicial functions, earlier being exercised either by the court or the central government. The Depositories Act 1996, dematerialization of securities was introduced by the Depositories Act 1996 and accordingly amendments were made to register of members and several other consequential things were incorporated. The Companies Amendment Act 1999. The following major changes to the Companies Act 1956. Companies allowed to issue sweat equity shares and to buy back their own securities. B. Facility for nomination provided for the benefit of share, debenture, deposit holders. C. An investor education and protection fund to be established. D. National Advisory Committee on Accounting Standards for Companies to be established. E. Prior approval of central government, not required for intercorporate investment, lending proposals subject to certain conditions. The Companies Amendment Act 2000. The following major amendments were introduced. A. Private companies and public companies to have a minimum paid-up capital of Rs 1 lakh and 5 lakh respectively. B. Provisions relating to deemed public companies became inoperative, and a new provision relating to conversion of a public company to a private company inserted in the Companies Act 1956. C. SEBI given powers regarding issue and transfer of securities and non-payment of dividend by listed public companies. D. Every listed company making initial public offer of any security for a sum of Rs 10 crores or more will have to issue the same only in a dematerialized form. The Companies Amendment Act 2002 on Companies. Second, the following changes to the Companies Act 1956. A. New parts are consisting of section 581A to 581ZT relating to producer companies inserted. B. The existing company law board was proposed to be dissolved and in its amendment, Act 2002, not enforced, place a national company law tribunal was to be constituted. C. The Board for Industrial and Financial Reconstruction was to be abolished and SICA was proposed to be repealed. The Companies Amendment Act 2006. This inserted new sections 610B, 610C, 610D, and 610E and also certain sections pertaining to Director Identification Number, DIN. With the advent of new technologies, this amendment introduced electronic filing, DIN, maintenance of electronic records in consistency with Information Technology Act 2000. Concept Paper OM Company Law 2004 J.J. Irani Report to frame a law that enables companies to achieve global competitiveness in a fast-changing economy. The government had taken up a fresh exercise for a comprehensive revision of the Companies Act 1956, albeit through a consultative process. As the first step in this direction, a concept paper on company law, drawn up in the legislative format, was exposed for public viewing on the electronic media so that all interested parties may not only express their opinions on the concepts involved but may also suggest formulations on various aspects of company law. The response to the concept paper on company law was tremendous. The government, therefore, felt it appropriate that the proposals contained in the concept paper and suggestions received thereon be put to merit evaluation by an independent expert committee. A committee was constituted on 2 December 2004 under the chairmanship of Dr. J.J. Irani, the then director, Tata Sons, with the task of advising the government on the proposed revisions to the Companies Act 1956 with the objective to have a simplified compact law that will be able to address the changes taking place in the national and international scenario, enable the adoption of internationally accepted best practices, as well as provide adequate flexibility for timely evolution of new arrangements in response to the requirements of ever-changing business models. The committee submitted its report to the government on 31 May 2005. Dr. J.J. Irani Expert Committee on Company Law had submitted its report charting out the roadmap for a flexible, dynamic and user-friendly new company law. The committee had taken a pragmatic approach keeping in view the ground realities and had sought to address the concerns of all the stakeholders to enable adoption of internationally accepted best practices. As one wades through the report, one finds an arduous zeal to ensure that flexibility is coupled with accountability and transparency. Be it the role of directors in the management of the company or the role of promoters at the time of incorporation or the responsibility of professionals in ensuring better governance, the report had made very dynamic and balanced recommendations. The report of the committee had also sought to bring in multifarious progressive and visionary concepts and endeavored to recommend a significant shift from the government approval regime to a shareholder approval and disclosure regime. The expert committee had recommended that private and small companies need to be given flexibilities and freedom of operations and compliance at a low cost. Companies with higher public interest should be subject to a stricter regime of corporate governance. Further, government companies and public financial institutions should be subject to similar parameters with respect to disclosures and corporate governance as other companies are subjected to attune the Indian company law with the global reforms taking place in the arena. The report of the committee had sought to bring in multifarious visionary concepts, which if accepted and acted upon would really simplify the voluminous and cumbersome Companies Act in the country. Companies Bill 2012. The government considered the recommendations of Irani Committee and also had detailed discussions and deliberations with various stakeholders viz. Industry chambers, professional institutes, government departments, legal experts and professionals, etc. Thereafter, the Companies Bill 2009 was introduced in the Lok Sabha on 3 August 2009. The bill laid greater emphasis on self-regulation and minimization of regulatory approvals in managing the affairs of the company. The bill promised greater shareholder democracy, vesting the shareholders with greater powers, containing stricter corporate governance norms, and requiring greater disclosures. The Companies Bill 2009 after introduction in Parliament was referred to the Parliamentary Standing Committee on Finance for examination, which submitted its report to Parliament on 31 August 2010. Certain amendments were introduced in the bill in the light of the report of the committee and a revised Companies Bill 2011 was introduced. This version was also referred to the Honorable Committee, which suggested certain further amendments. The amended bill was passed by the Lok Sabha on 18 December 2012 and by the Rajya Sabha on 8 August 2013. The bill was retitled as Companies Bill 2012. Companies Act 2013. The Companies Bill 2012 finally became the Companies Act 2013. It received the assent of the President on the 29th of August 2013 and was notified in the Gazette of India on the 30th of August 2013. Companies Act 2013 has undergone amendments 4 times so far. Companies Amendment Act 2015 and Companies Amendment Act 2017 aimed at enhancing efficiency and promoting ease of doing business. The Act was also amended by the Insolvency and Bankruptcy Code 2016 and Finance Act 2017. The Insolvency and Bankruptcy Code 2016 led to omission of various sections, i.e. Section 253 to Section 269, Section 289, Section 304 to Section 323 and Section 325. The Finance Act 2017 amended Section 182 with regard to prohibitions and restrictions regarding political contributions. So far, Ministry has come out with several circulars, notifications, orders and various amendment rules to facilitate better and smooth implementation of the Act. The Companies Act 2013 introduced new concepts supporting enhanced disclosure, accountability, better board governance, better facilitation of business and so on. It includes associate company, 1. person company, small company, dormant company, independent director, women director, resident director, special court, secretarial standards, secretarial audit, class action, registered valuers, rotation of auditors, vigil mechanism, corporate social responsibility, e-voting, etc. Meaning and definition of a company. Let's now understand what is a company and how it is positioned. The word company is derived from the Latin word com equals with or together, pinus equals spread, and it originally referred to an association of persons who took their meals together. In the leisurely past, merchants took advantage of festive gatherings to discuss business matters. Nowadays, the company form of organization has assumed great importance. In popular parlance, a company denotes an association of like-minded persons formed for the purpose of carrying on some business or undertaking. A company is a corporate body and a legal person having status and personality distinct and separate from the members constituting it. It is called a body corporate because the persons composing it are made into one body by incorporating it according to the law and clothing it with legal personality. The word corporation is derived from the Latin term corpus, which means body. Accordingly, corporation is a legal person created by a process other than natural birth. It is, for this reason, sometimes called artificial legal person. As a legal person, a corporate is capable of enjoying many rights and incurring many liabilities of a natural person. An incorporated company owes its existence either to a special act of parliament or to company law. Public corporations like life insurance, Corporation of India, SBI etc., have been brought into existence through special acts of Parliament, whereas companies like Tata Steel Limited, Reliance Industries Limited have been formed under the Company Law, i.e. Companies Act, 1956, which is replaced by the Companies Act, 2013. In the legal sense, a company is an association of both natural and artificial persons, and is incorporated under the existing law of a country. In terms of the Companies Act, 2013, Act Number 18 of 2013, a company means a company incorporated under this act, or under any previous company law, Section 220. In common law, a company is a legal person or legal entity, separate from and capable of surviving beyond the lives of its members. A company is rather a legal device for the attainment of social and economic end. It is, therefore, a combined political, social, economic and legal institution. Thus, the term company has been described in many ways. It is a means of cooperation and organization in the conduct of an enterprise. It is an intricate, centralized, economic and administrative structure run by professional managers who hire capital from the investor. Lord Justice Lingley has defined a company as an association of many persons who contribute money or money's worth to a common stock and employ it in some trade or business and who share the profit and loss arising therefrom. The common stock so contributed is denoted in money and is the capital of the company. The persons who contributed in it or form it, or to whom it belongs, are members. The proportion of capital to which each member is entitled is his share. The shares are always transferable, although the right to transfer them may be restricted. Nature and characteristics of a company. Since a corporate body, i.e. a company, is the creation of law, it is not a human being, it is an artificial juridical person, i.e. created by law, and it is clothed with many rights, obligations, powers and duties prescribed by law. The most striking characteristics of a company are discussed below. Corporate personality. A company incorporated under the Act is vested with a corporate personality, so it bears its own name, acts under name, has a seal of its own, and its assets are separate and distinct from those of its members. It is a different person from the members who compose it. Therefore it is capable of owning property, incurring debts, borrowing money, having a bank account, employing people, entering into contracts and suing, or being sued in the same manner as an individual. Its members are its owners, however they can be its creditors simultaneously. A shareholder cannot be held liable for the acts of the company even if he holds virtually the entire share capital. The shareholders are not the agents of the company and so they cannot bind it by their acts. The company does not hold its property as an agent or trustee for its members and they cannot sue to enforce its rights, nor can they be sued in respect of its liabilities. Thus, incorporation is the act of forming a legal corporation as a juristic person. A juristic person is in law also conferred with rights and obligations and is dealt in accordance with law. In other words, the entity acts like a natural person but only through a designated person, whose acts are processed within the ambit of law. Shiromani Gurudwara Prabandhak Committee, V. Shri Samnath Das Air. 2000 SCW 139. Case example: the case of Salomon v. Salomon and Company Limited, 1897, AC. 22. The above case has clearly established the principle that once a company has been validly constituted under the Companies Act, it becomes a legal person distinct from its members, and for this purpose it is immaterial whether any member holds a large or small proportion of the shares, and whether he holds those shares as beneficially or as a mere trustee. In the case, Salomon had, for some years, carried on a prosperous business as a leather merchant and boot manufacturer. He formed a limited company consisting of himself, his wife, his daughter and his 4 sons as the shareholders, all of whom subscribed to 1 share each, so that the actual cash paid as capital was £7. Salomon sold his business, which was perfectly solvent at that time, to the company formed by him for the sum of £38,782. The company's nominal capital was £40,000 in £1 shares. In part payment of the purchase money for the business sold to the company, debentures of the amount of £10,000 secured by a floating charge on the company's assets were issued to Salomon, who also applied for and received an allotment of £20,001 fully paid shares. The remaining amount of £8,782 was paid to Salomon in cash. Salomon was the managing director and 2 of his sons were other directors. The company soon ran into difficulties and the debenture holders appointed a receiver and the company went into liquidation. The total assets of the company amounted to £6,050. Its liabilities were £10,000 secured by debentures, £8,000 owing to unsecured trade creditors, who claimed the whole of the company's assets, viz. £6,050, on the ground that, as the company was a mere alias or agent for Salomon, they were entitled to payment of their debts in priority to debentures. They further pleaded that Salomon, as a principal beneficiary, was ultimately responsible for the debts incurred by his agent or trustee on his behalf. Their lordships of the House of Lords observed, the company is a different person altogether from the subscribers of the memorandum, and though it may be that after incorporation the business is precisely the same as before, the same persons are managers, and the same hands receive the profits, the company is not, in law, their agent or trustee. The statute enacts nothing as to the extent or degree of interest, which may be held by each of the 7, or as to the proportion of interest, or influence possessed by one or majority, of the shareholders over others. There is nothing in the Act requiring that the subscribers to the memorandum should be independent or unconnected, or that they or any of them should take a substantial interest in the undertakings, or that they should have mind or will of their own, or that there should be anything like a balance of power in the constitution of company. Case example: the case of Levy Lees Air Farming Limited, 1961, AC, 12, BC. The above case illustrates the application of the principles established in Salomon's case, supra. In this case, a company was formed for the purpose of aerial top dressing. Lee, a qualified pilot, held all but one of the shares in the company. He voted himself the managing director and got himself appointed by the articles as chief pilot at a salary. He was killed in an air crash while working for the company. His widow claimed compensation for the death of her husband in the course of his employment. The company opposed the claim on the ground that Lee was not a worker, as the same person could not be the employer and the employee. The Privy Council held that Lee and his company were distinct legal persons which had entered into contractual relationships under which he became the chief pilot, a servant of the company. In his capacity of managing director he could, on behalf of the company, give himself orders in his other capacity of pilot, and the relationship between himself, as pilot and the company, was that of servant and master. Lee was a separate person from the company he formed and his widow was held entitled to get the compensation. In effect, the magic of corporate personality enabled him, Lee, to be the master and servant at the same time, and enjoy the advantages of both. The decision of the Calcutta High Court in the Carnally Tea Company Limited, 1886, ILR 13 calories, 43, recognized the principle of separate legal entity even much earlier than the decision in Salomon v. Salomon, Company Limited case. Certain persons transferred a tea estate to a company and claimed exemptions from ad valorem duty on the ground that since they themselves were also the shareholders in the company, it was nothing but a transfer from them in one name to themselves under another name. While rejecting this, Calcutta High Court observed, the company was a separate person, a separate body altogether from the shareholders, and the transfer was as much a conveyance, a transfer of the property, as if the shareholders had been totally different persons. Case example: New Horizons Limited v. Union of India. Air 1994, Delhi 126. The experience of a shareholder of a company can be regarded as experience of a company. The tender of the company, New Horizons Limited, for publication of telephone directory was not accepted by the Tender Evaluation Committee on the ground that the company had nothing on record to show that it had the technical experience required to be possessed to qualify for tender. On appeal, the rejection of tender was upheld by the Delhi High Court. The judgment of the Delhi High Court was reversed by the Supreme Court, which observed as under, once it is held that NHL, New Horizons Limited, is a joint venture, as claimed by it in the tender, the experience of its various constituents namely, TPI, Thomson Press India Limited, LMI, Living Media India Limited, and WML, World Media Limited, as well as IP People, Integrated Information Purity Limited, had to be taken into consideration if the Tender Evaluation Committee had adopted the approach of a prudent businessman. Seeing through the veil covering the face of NHL, it will be found that as a result of reorganization in 1992, the company is functioning as a joint venture wherein the Indian Group, TPI, LMI and WML, and Mr. Arun Puri holds 60% shares and the Singapore-based company, IIPL, holds 40% shares. Both the groups have contributed towards the resources of the joint venture in the form of machines, equipment and expertise in the field. The company is in the nature of partnership between the Indian group of companies and Singapore-based company who have jointly undertaken this commercial enterprise wherein they will contribute to the assets and share the risk. In respect of such a joint venture company, the experience of the company can only mean the experience of the constituents of the joint venture, i.e. the Indian group of companies, TPI, LMI and WML, and the Singapore-based company, IIPL, New Horizons Limited and another v. Union of India, 1995, 1 Comp, LJ 100 SC. 2. Company as an artificial person. A company is an artificial person, created by law. It is not a human being but it acts through human beings. It is considered as a legal person which can enter into contracts, possess properties in its own name, sue, and can be sued by others, etc. It is called an artificial person since it is invisible, intangible, existing only in the contemplation of law. It is capable of enjoying rights and being subject to duties. Case example: Union Bank of India v. Dadar International Construction. Another. 2001, 42 CLA, 296 SC. In this case, the question which arose before the court was whether a company is entitled to sue as an indigent, pure person under Order 33. Rule 1 of the Civil Procedure Code, 1908. The aforesaid order permits persons to file suits under the code as pauper, indigent persons if they are unable to bear the cost of litigation. The appellant in this case had objected to the contention of the company which had sought permission to sue as an indigent person. The point of contention was that, the appellant being a public limited company, it was not a person within the purview of Order 33, Rule 1 of the code, and the person referred to only a natural person and not to other juristic persons. The Supreme Court held that the word person mentioned in Order 33, Rule 1 of the Civil Procedure Code, 1908, included any company as association or body of individuals, whether incorporated or not. The court observed that the word person had to be given its meaning in the context in which it was used, and being a benevolent provision, it was to be given an extended meaning. Thus, a company may also file a suit as an indigent person. 3. Company is not a citizen. The company, though a legal person, is not a citizen under the Citizenship Act, 1955 or the Constitution of India. In State Trading Corporation of India Limited, VCTO, AR, 1963 SC. 1811, the Supreme Court held that the State Trading Corporation, though a legal person, was not a citizen and can act only through natural persons. Nevertheless, it is to be noted that certain fundamental rights enshrined in the Constitution for protection of person, e.g., right to equality, Article 14, etc., are also available to company. Section 2, F, of Citizenship Act, 1955, expressly excludes a company or association or body of individuals from citizenship. CASE example in R.C. Cooper v. Union of India, A 1970 SC 564. In this case, the Supreme Court held that where the legislative measures directly touch the company of which the petitioner is a shareholder, he can petition on behalf of the company, if by the impugned action, his rights are also infringed. In that case, the court entertained the petition under Article 32 of the Constitution at the instance of a director as shareholder of a company and granted relief. It is, therefore, to be noted that an individual's right is not lost by reason of the fact that he is a shareholder of the company. Case example: Bennett Coleman Company v. Union of India, A 1973 SC 106. In this case, the Supreme Court stated that it is now clear that the fundamental rights of shareholders as citizens are not lost when they associate to form a company. When their fundamental rights as shareholders are impaired by state action, their rights as shareholders are protected. The reason is that the shareholders' rights are equally and necessarily affected if the rights of the company are affected. If company has nationality and residence, though it is established through judicial decisions that a company cannot be a citizen, yet it has nationality, domicile and residence. In Gask v Inland Revenue Commissioners, 1940, 2 KB, 88, McNayton, J held that a limited company is capable of having a domicile and its domicile is the place of its registration and that domicile clings to it throughout its existence. He observed in this case, it was suggested that a body corporate has no domicile. It is quite true that a body corporate cannot have a domicile in the same sense as an individual, but by analogy with a natural person the attributes of residence, domicile and nationality can be given to a body corporate. In Tulika v Parry and Company, 1903, ILR, 27 Med. 315, Kelly CB observed, a joint stock company resides where its place of incorporation is, where the meetings of the whole company or those who represent it are held and where its governing body meets in bodily presence for the purposes of the company and exercises the powers conferred upon it by statute and by the Articles of Association. V. Limited liability. The privilege of limited liability for business debts is one of the principal advantages of doing business under the corporate form of organization. The company, being a separate person, is the owner of its assets and bound by its liabilities. The liability of a member as shareholder extends to the contribution to the capital of the company up to the nominal value of the shares held and not paid by him. Members, even as a whole, are neither the owners of the company's undertakings nor liable for its debts. In other words, a shareholder is liable to pay the balance, if any, due on the shares held by him, when called upon to pay and nothing more, even if the liabilities of the company far exceed its assets. This means that the liability of a member is limited. For example, if A holds shares of the total nominal value of 1,000 and has already paid fee FFPPP/dash or 50% of the value as part payment at the time of allotment, he cannot be called upon to pay more than 500. The amount remaining unpaid on his shares. If he holds fully paid shares, he has no further liability to pay even if the company is declared insolvent. In the case of a company limited by guarantee, the liability of members is limited to a specified amount of the guarantee mentioned in the memorandum. Buckley, J. Indre, London and Globe Finance Corporation, 1903, 1ch.d.7, today at 73 where WN, has observed, the statutes relating to limited liability have probably done more than any legislation of the last 50 years to further the commercial prosperity of the country. They have, to the advantage of the investor as well as of the public, allowed an encouraging aggregation of small sums into large capitals which have been employed in undertakings of great public utility, largely increasing the wealth of the country. Exceptions to the principle of limited liability, members are severally liable in certain cases if at any time the number of members of a company is reduced, in the case of a public company, below 7, in the case of a private company, below 2, and the company carries on business for more than 6 months while the number of members is so reduced. Every person who is a member of the company, during the time that it so carries on business after those 6 months and is cognizant of the fact that it is carrying on business with less than 7 members or 2 members, as the case may be, shall be severally liable for the payment of the whole debts of the company contracted during that time, and may be severally sued therefore. Section 3A, when the company is incorporated as an unlimited company under Section 3(2)(c) of the Act, where a company has been got incorporated by furnishing any false or incorrect information or representation or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent action, the tribunal may, on an application made to it, on being satisfied that the situation so warrants, direct that liability of the members of such company shall be unlimited. Section 7(b). Further, under Section 339(1), where in the course of winding up it appears that any business of the company has been carried on with an intent to defraud creditors of the company or any other persons or for any fraudulent purpose, the tribunal may declare the persons who were knowingly parties to the carrying on of the business, in the manner aforesaid as personally liable, without limitation of liability, for all or any of the debts, liabilities of the company. Section 339, under Section 35(3), where it is proved that a prospectus has been issued with intent to defraud the applicants for the securities of a company or any other person, or for any fraudulent purpose, every person who was a director at the time of issue of the prospectus or has been named as a director in the prospectus, or every person who has authorized the issue of prospectus, or every promoter or a person referred to as an expert in the prospectus shall be personally responsible, without any limitation of liability, for all or any of the losses or damages that may have been incurred by any person who subscribed to the securities on the basis of such prospectus. As per Section 75(1), where a company fails to repay the deposit or part thereof, or any interest thereon referred to in Section 74 within the time specified or such further time as may be allowed by the tribunal, and it is proved that the deposits had been accepted with intent to defraud the depositors or for any fraudulent purpose, every officer of the company who was responsible for the acceptance of such deposit shall, without prejudice to other liabilities, also be personally responsible, without any limitation of liability, for all or any of the losses or damages that may have been incurred by the depositors. Section 224(5) states that where the report, made by an inspector, states that fraud has taken place in a company and due to such fraud any director, key managerial personnel, other officer of the company or any other person or entity, has taken undue advantage or benefit, whether in the form of any asset, property or cash or in any other manner, the central government may file an application before the tribunal for appropriate orders with regard to disgorgement of such asset, property or cash, and also for holding such director, key managerial personnel, officer or other person liable personally without any limitation of liability. V. Perpetual succession. An incorporated company never dies, except when it is wound up as per law. A company, being a separate legal person, is unaffected by death or departure of any member, and it remains the same entity, despite total change in the membership. Perpetual succession means that the membership of a company may keep changing from time to time, but that shall not affect its continuity. The membership of an incorporated company may change either because one shareholder has sold, transferred his shares to another, or his shares devolve on his legal representatives on his death, or he ceases to be a member under some other provisions of the Companies Act. Thus, perpetual succession denotes the ability of a company to maintain its existence by the succession of new individuals who step into the shoes of those who cease to be members of the company. Professor L.C. Bigar rightly mentions, members may come and go, but the company can go on forever. During the war, all the members of one private company, while in general meeting, were killed by a bomb, but the company survived. Not even a hydrogen bomb could have destroyed it. 7. Separate property. A company, being a legal person and entirely distinct from its members, is capable of owning, enjoying and disposing of property in its own name. The company is the real person in which all its property is vested, and by which it is controlled, managed and disposed of. Their lordships of the Madras High Court and R.F. Perumal v.H. John Devan, A.R. 1960 Med. 43 held that no member can claim himself to be the owner of the company's property during its existence or in its winding up. A member does not even have an insurable interest in the property of the company. Case example: Mrs. Bacha F. Guzdavi, the Commissioner of Income Tax, Bombay, A.R. 1955 SC. 74. The Supreme Court in this case held that, though the income of a tea company is entitled to be exempted from income tax up to 60% being partly agricultural, the same income when received by a shareholder in the form of dividend cannot be regarded as agricultural income for the assessment of income tax. It was also observed by the Supreme Court that a shareholder does not, as is erroneously believed by some people, become the part owner of the company or its property. He is only given certain rights by law, e.g., to receive notice of or to attend or vote at the meetings of the shareholders. The court refused to identify the shareholders with the company and reiterated the distinct personality of the company. 8. Transferability of shares. The capital of a company is divided in two parts, called shares. The shares are said to be movable property and, subject to certain conditions, freely transferable, so that no shareholder is permanently or necessarily wedded to a company. When the joint stock companies were established, the object was that their shares should be capable of being easily transferred. Section 44 of the Companies Act, 2013, enunciates the principle by providing that the shares held by the members are movable property and can be transferred from one person to another in the manner provided by the articles. If the articles do not provide anything for the transfer of shares, and the regulations contained in Table F in Schedule I to the Companies Act, 2013, are also expressly excluded, the transfer of shares will be governed by the general law relating to transfer of movable property. A member may sell his shares in the open market and realize the money invested by him. This provides liquidity to a member, as he can freely sell his shares, and ensures stability to the company, as the member is not withdrawing his money from the company. The stock exchanges provide adequate facilities for the sale and purchase of shares. Further, as of now, in most of the listed companies, the shares are also transferable through electronic mode, i.e. through depository participants in dematerialized form instead of physical transfers. However, there are restrictions with respect to transferability of shares of a private limited company. 9. Capacity to sue and be sued. A company, being a body corporate, can sue and be sued in its own name. To sue means to institute legal proceedings against a person or to bring a suit in a court of law. All legal proceedings against the company are to be instituted in its name. Similarly, the company may bring an action against anyone in its own name. A company's right to sue arises when some loss is caused to the company, i.e. to the property or the personality of the company. Hence, the company is entitled to sue for damages in libel or slander, as the case may be. Floating Services Limited, VMB San Francisco de Paloa, 2004, 52 SCL 762, Guj. A company, as a person distinct from its members, may even sue one of its own members. A company has a right to seek damages where defamatory material published about it affects its business. Where video cassettes were prepared by the workmen of a company showing their struggle against the company's management, it was held to be not actionable unless shown that the contents of the cassette would be defamatory. The court did not restrain the exhibition of the cassette. TVS Employees Federation v. TVS and Sons Limited, 1996, 87 Com cases 37. The company is not liable for contempt committed by its officer. Lalit Suraj Mal Kanodia v. Office Tiger Database Systems India, P. Limited, 2006, 129, Com cases 192 Mad. X. Contractual rights. A company, being a legal entity different from its members, can enter into contracts for the conduct of the business in its own name. A shareholder cannot enforce a contract made by his company. He is neither a party to the contract, nor be entitled to the benefit derived from it, as a company is not a trustee for its shareholders. Likewise, a shareholder cannot be sued on contracts made by his company. The distinction between a company and its members is not confined to the rules of privity but permeates the whole law of contract. Thus, if a director fails to disclose a breach of his duties towards his company, and in consequence a shareholder is induced to enter into a contract with the director on behalf of the company, which he would not have entered into had there been disclosure, the shareholder cannot rescind the contract. Similarly, a member of a company cannot sue in respect of torts committed against the company, nor can he be sued for torts committed by the company. Therefore, the company as a legal person can take action to enforce its legal rights, or be sued for breach of its legal duties. Its rights and duties are distinct from those of its constituent members. Limitation of action. A company cannot go beyond the powers stated in its Memorandum of Association. The Memorandum of Association of the company regulates the powers and fixes the objects of the company, and provides the edifice upon which the entire structure of the company rests. The actions and objects of the company are limited within the scope of its Memorandum of Association. In order to enable it to carry out its actions without such restrictions and limitations in most cases, sufficient powers are granted in the Memorandum of Association. But once the powers have been laid down, it cannot go beyond such powers unless the Memorandum of Association itself altered prior to doing so. 12. Separate management. As already noted, the members may derive profits without being burdened with the management of the company. They do not have effective and intimate control over its working, and they elect their representatives as directors on the board of directors of the company to conduct corporate functions through managerial personnel employed by them. In other words, the company is administered and managed by its managerial personnel. 13. Voluntary association for profit. A company is a voluntary association for profit. It is formed for the accomplishment of some stated goals, and whatsoever profit is gained is divided among its shareholders, or saved for the future expansion of the company. Only a Section 8 company can be formed with no profit motive. 14. Termination of existence. A company, being an artificial juridical person, does not die a natural death. It is created by law, carries on its affairs according to law throughout its life, and ultimately is effaced by law. Generally, the existence of a company is terminated by means of winding up. However, to avoid winding up, sometimes companies adopt strategies like reorganization, reconstruction, and amalgamation. To sum up, a company is a voluntary association for profit with capital divisible into transferable shares with a limited liability, having a distinct corporate entity, and a common seal with perpetual succession. Company vis-a-vis other forms of business. Though there are a number of similarities between a limited company and other forms of associations, there are a great number of dissimilarities as well. In the following paragraphs, a limited company is distinguished from a partnership firm, a Hindu undivided family, HUF, business, and LLP. Distinction between partnership firm and company. The principal points of distinction between a partnership firm and a company are as follows. Partnership firm. Company. A partnership firm is not distinct from the several persons who form the partnership. A company is a distinct legal person. In a partnership, the property of the firm is the property of the individuals comprising it. In a company, it belongs to the company and not to the individuals who are its members. Creditors of a partnership firm are creditors of individual partners, and a decree against the firm can be executed against the partners jointly and severally. The creditors of a company can proceed only against the company and not against its members. Partners are the agents of the firm. A partner can dispose of the property and incur liabilities as long as he acts in the course of the firm's business. Members of a company are not its agents. A member of a company cannot dispose of the property and incur liabilities in the course of the company's business. A partner cannot contract with his firm. A member can contract with his company. A partner cannot transfer his share and make the transferee a member of the firm without the consent of the other partners. A company's share can ordinarily be transferred. A partner's liability is always unlimited. The liability of shareholder may be limited either by shares or a guarantee. The death or insolvency of a partner dissolves the firm, unless otherwise provided. A company has perpetual succession, i.e. the death or insolvency of a shareholder or all of them does not affect the life of the company. The accounts of a firm are audited at the discretion of the partners. A company is required to have its accounts audited annually by a chartered accountant. A partnership firm, on the other hand, is the result of an agreement and can be dissolved at any time by agreement among the partners. A company, being a creation of law, can only be dissolved as laid down by law. Distinction between a Hindu undivided family business and a company. Hindu undivided family business. Company. A Hindu undivided family business consists of homogeneous, unvarying members, since it consists of members of the joint family itself. A company consists of heterogeneous, varied or diverse members. In a Hindu undivided family business, the karta, manager, has the sole authority to contract debts for the purpose of the business. Other co-partners cannot do so. There is no such a system in a company. A person becomes a member of a Hindu undivided family business by virtue of birth. There is no provision to that effect in the company. No registration is compulsory for carrying on business for gain by a Hindu undivided family, even if the number of members exceeds 20. Shyamalal Roy v. Madhusudan Roy, Air 1959 calories, 380, 385. Registration of a company is compulsory. Distinction between limited liability partnership, LLP, and a company. LLP is an alternative corporate business form that gives the benefits of limited liability of a company and the flexibility of a partnership. LLP can continue its existence irrespective of changes in partners. It is capable of entering into contracts and holding property in its own name. LLP is a separate legal entity, is liable to the full extent of its assets, but liability of the partners is limited to their agreed contribution in the LLP. Further, no partner is liable on account of the independent or unauthorized actions of other partners. Thus, individual partners are shielded from joint liability created by another partner's wrongful business decisions or misconduct. Mutual rights and duties of the partners within the LLP are governed by an agreement between the partners or between the partners and the LLP, as the case may be. The LLP, however, is not relieved of the liability for its other obligations as a separate entity. Since LLP contains elements of both a corporate structure as well as a partnership firm structure, LLP is called a hybrid between a company and a partnership. LLP is a body corporate and a legal entity separate from its partners, having perpetual succession. LLP form is a form of business model which I is organized and operates on the basis of an agreement. 2. Provides flexibility without imposing detailed legal and procedural requirements. 3. Enables professional, technical expertise and initiative to combine with financial risk-taking capacity in an innovative and efficient manner. A basic difference between an LLP and a company lies in that the internal governance structure of a company is regulated by statute, i.e. Companies Act, whereas for an LLP it would be by a contractual agreement between partners. The management ownership divide inherent in a company is not there in a limited liability partnership. LLP have more flexibility as compared to a company. LLP have lesser compliance requirements as compared to a company. Doctrine of lifting of or piercing the corporate veil. The separate personality of a company is a statutory privilege and it must be used for legitimate business purposes only. Where a fraudulent and dishonest use is made of the legal entity, the individuals concerned will not be allowed to take shelter behind the corporate personality. The court will break through the corporate shell and apply the principle, doctrine of what is called as lifting of or piercing the corporate veil. the court will look behind the corporate entity and take action as though no entity separate from the members existed, and make the members or the controlling persons liable for debts and obligations of the company. The corporate veil is lifted when in defense proceedings, such as for the evasion of tax, an entity relies on its corporate personality as a shield to cover its wrongdoings. BSN, UK, Limited, v. Janardhan Mohandas Rajan Pillai. 1996, 86 Com cases 371, Bomb. However, the shareholders cannot ask for the lifting of the veil for their purposes. This was held in Premalata Bhatia v. Union of India, 2004, 58 CL 217, Delhi, wherein the premises of a shop were allotted on a license to the individual licensee. She set up a wholly owned private company and transferred the premises to that company without government consent. She could not remove the illegality by saying that she and her company were virtually the same person. Statutory recognition of lifting of corporate veil. The Companies Act, 2013 itself contains some provisions, sections 7, 251, 1, and 339, which lift the corporate veil to reach the real forces of action. Section 7, deals with punishment for incorporation of company by furnishing false information. Section 251, 1, deals with liability for making fraudulent application for removal of name of company from the register of companies, and Section 339 deals with liability for fraudulent conduct of business during the course of winding up. Lifting of corporate veil under judicial interpretation. Ever since the decision in Salomon v. Salomon, Company Limited, 1897, AC, 22, normally courts are reluctant or at least very cautious to lift the veil of corporate personality to see the real persons behind it. Nevertheless, courts have found it necessary to disregard the separate personality of a company in the following situations. A. Where the corporate veil has been used for commission of fraud or improper conduct. In such a situation, courts have lifted the veil and looked at the realities of the situation. Case example in Jones v. Lipman, 1962, IWLR, 832A agreed to sell certain land to be pending completion of formalities of the said deal. A sold and transferred the land to a company which he had incorporated with a nominal capital of 100 British pound and of which he and a clerk were the only shareholders and directors. This was done in order to escape a decree for specific performance in a suit brought by B. The court held that the company was the creature of A and must to avoid recognition, and that in the eyes of equity A must complete the contract, since he had the full control of the limited company in which the property was vested, and was in a position to cause the contract in question to be fulfilled. B. Where corporate facade is really only an agency instrumentality. See ASE example. INRI, RG Films Limited, 1953, 1 All 615. An American company produced a film in India technically in the name of a British company, 90% of whose capital was held by the president of the American company which financed the production of the film. Board of Trade refused to register the film as a British film, which stated that English company acted merely as the nominee of the American corporation. C. Where the conduct conflicts with public policy, courts lifted the corporate veil for protecting the public policy. See ASE example in Carners Bros. v. Carners, 1940, 4 All 179. The principle was applied against the managing director, who made use of his position contrary to public policy. In this case, the House of Lords determined the character of the company as enemy company, since the persons who were de facto in control of its affairs were residents of Germany, which was at war with England at that time. The alien company was not allowed to proceed with the action, as that would have meant giving money to the enemy, which was considered as monstrous and against public policy. D. Further, in Daimler Company Limited, v. Continental Tire, Rubber Company, 1916, 2 AC, 307, it was held that a company will be regarded as having enemy character if the persons having de facto control of its affairs are resident in an enemy country, or, wherever they may be, are acting under instructions from or on behalf of the enemy. E. Where it was found that the sole purpose for which the company was formed was to evade taxes, the court will ignore the concept of separate entity and make the individuals concerned liable to pay the taxes which they would have paid but for the formation of the company. Case example A. Sir Dinshaw Manik G. Petty, A.R. 1927, Bombay 371. The facts of the case are that the assessee was a wealthy man enjoying large dividend and interest income. He formed 4 private companies and agreed with each to hold a block of investment as an agent for it. Income received was credited in the accounts of the company, but the company handed back the amount to him as a pretended loan. This way he divided his income in 4 parts in a bid to reduce his tax liability. But it was held, the company was formed by the assessee purely and simply as a means of avoiding super tax, and the company was nothing more than the assessee himself. It did no business, but was created simply as a legal entity to ostensibly receive the dividends and interests, and to hand them over to the assessee as pretended loans. The court decided to disregard the corporate entity as it was being used for tax evasion. Vodafone case, one of the most recent and also a landmark case of the Supreme Court, is its decision in the case of Vodafone International Holdings BV v. Union of India. Another, SLP, C. No. 26,529 of 2010. In judgment, the Supreme Court set aside the Bombay Court's judgment directing Vodafone International Holdings BV, Vodafone, to pay 110 billion Indian rupee as withholding tax in a transaction that took place offshore. The facts, as briefly put, are that in May 2007 Vodafone, incorporated in the Netherlands, acquired from Hong Kong-based Hutchison Group, the entire share capital of CGP Investments Holdings Limited, CGP, a company incorporated in the Cayman Islands, which in turn controlled a 67% interest in Hutchison SA Limited, HEL, Hutchison's Indian mobile business. The Indian income tax authorities contended that capital gains were made by Hutchison in India, and that Vodafone was therefore liable to pay withholding tax thereon, amounting to approximately 110 billion Indian rupee, the sale price being $11.2 billion. Vodafone challenged the tax demand in the Bombay court, which ruled in favor of the income tax authorities, holding that the essence of the transaction was a change in the controlling interest in HEL, which constituted a source of income in India. Vodafone appealed to the Supreme Court, which overruled the High Court and held that the transaction fell outside India's territorial tax jurisdiction and was hence not taxable. The judgment was not only important in the context of taxation, but also covers other issues of corporate law. One of these is in the context of the principle of the corporate veil, and the circumstances under which it may be lifted, particularly in the context of commercial cross-border transactions and tax avoidance. The court recognized the fundamental principle of the corporate veil by noting that the approach of both the corporate and tax laws, particularly in the matter of corporate taxation, generally is founded on the above-mentioned separate entity principle, i.e., treat a company as a separate person. The Indian Income Tax Act, 1961, in the matter of corporate taxation, is founded on the principle of the independence of companies and other entities subject to income tax. It observed in the context of parent-subsidiary relationships that it is generally accepted that the group parent company would give guidance to group subsidiaries, but that by itself would not justify piercing the veil or imply that the subsidiaries are to be deemed residents of the state in which the parent company resides, and that a subsidiary and its parent are totally distinct taxpayers. 6 factors that may be considered to determine whether the transaction is a bogus and whether in a specific case the corporate veil may be lifted are: I. The concept of participation in investment. 2. The duration of time during which the holding structure exists. 3. The period of business operations in India. 5. The generation of taxable revenues in India. V. The timing of the exit. And V. The continuity of business on such exit. In the final analysis, the Supreme Court decided against lifting the corporate veil in Vodafone, as the tax authorities failed to establish that the transaction was a bogus or tax avoidance scheme. F. Avoidance of welfare legislation is as common as avoidance of taxation, and the approach in considering problems arising out of such avoidance has necessarily to be the same in, therefore, where it was found that the sole purpose for the formation of the new company was to use it as a device to reduce the amount to be paid by way of bonus to workmen. The Supreme Court upheld the piercing of the veil to look at the real transaction. Case example: the workmen employed in Associated Rubber Industries Limited, Bhavnagar v. the Associated Rubber Industries Limited, Bhavnagar, and another, AR, 1986. SC1. The facts of the case were that a new company was created wholly by the principal company with no assets of its own except those transferred to it by the principal company, with no business or income of its own except receiving dividends from shares transferred to it by the principal company, i.e. only for the purpose of splitting the profits into 2 hands and thereby reducing the obligation to pay bonus. The Supreme Court of India held that the new company was formed as a device to reduce the gross profits of the principal company and thereby reduce the amount to be paid by way of bonus to workmen. The amount of dividends received by the new company should, therefore, be taken into account in assessing the gross profit of the principal company. G. And other instance of corporate veil arrived at by the court arose in Kapila Hingarani v. State of Bihar. CASE example: Kapila Hingarani v. State of Bihar, 2003, 4, scale 712. In this case, the petitioner had alleged that the state of Bihar had not paid salaries to its employees and PSUs etc. for long periods, resulting in starvation deaths, but the respondent took the stand that most of the undertakings were incorporated under the provisions of the Companies Act, 1956, hence the rights etc. of the shareholders should be governed by the provisions of the Companies Act and the liabilities of the PSUs should not be passed on to the state government by resorting to the doctrine of lifting the corporate veil. The court observed that the state may not be liable in relation to the day-to-day functioning of the PSUs, but its liability would arise on its failure to perform the constitutional duties and the functions of these undertakings. It is so because life means something more than mere ordinal existence. The inhibition against deprivation of life extends to all those limits and faculties by which life is enjoyed. H. Where it is found that a company has abused its corporate personality for an unjust and inequitable purpose, the court would not hesitate to lift the corporate veil. Further, the corporate veil could be lifted when acts of a corporation are allegedly opposed to justice, convenience and interests of revenue or workmen, or are against public interest. Thus, in appropriate cases, the courts disregard the separate corporate personality and look behind the legal person, or lift the corporate veil. Lifting the corporate veil of small-scale industry: where small-scale industries were given certain exemptions and the company owning an industry was controlled by some group of persons or companies, it was held that it was permissible to lift the veil of the company to see whether it was the subsidiary of another company and, therefore, not entitled to the proposed exemptions. In ALSA Limited, v. Union of India, 1996, 87 Com Cases 599, Delhi. Use of corporate veil for hiding criminal activities: where the defendant used the corporate structure as a device or facade to conceal his criminal activities, evasion of customs and excise duties payable by the company. The court could lift the corporate veil and treat the assets of the company as the realizable property of the shareholder. For example, in a case, there was a prima facie case that the defendants controlled the 2 companies, the companies had been used for the fraudulent evasion of excise duty on a large scale. The defendant regarded the companies as carrying on a family business, and that they had benefited from companies, cash in substantial amounts, and further no useful purpose would have been served by involving the companies in the criminal proceedings. In all these circumstances, it was therefore appropriate to lift the corporate veil and treat the stock in the companies, warehouses, and the companies, motor vehicles as realizable property held by the defendants. The court said that the excise department is not to be criticized for not charging the companies. The more complex commercial activities become, the more vital it is for prosecuting authorities to be selective in whom and what they charge, so that issues can be presented in as clear and short form as possible. In the present case, it seemed that no useful purpose would have been served by initiating criminal proceedings. H. and others, Restraint Order, Realizable Property, Re. 1996, 2 BCLC 500 at 511, 512, CA. Applicability of Companies Act, 2013 and key concepts. A. Applicability according to Section 1 of the Companies Act, 2013. The Act extends to whole of India and the provisions of the Act shall apply to the following. A. Companies incorporated under this Act or under any previous company law. B. Insurance companies, except insofar as the said provisions are inconsistent with the provisions of the Insurance Act, 1938, 4 of 1938, or the Insurance Regulatory and Development Authority Act, 1999, 41 of 1999. C. Banking companies, except insofar as the said provisions are inconsistent with the provisions of the Banking Regulation Act, 1949, 10 of 1949. D. Companies engaged in the generation or supply of electricity, except insofar as the said provisions are inconsistent with the provisions of the Electricity Act, 2003, 36 of 2003. E. Any other company governed by any special act for the time being in force, except insofar as the said provisions are inconsistent with the provisions of such a special act. And F. Such body corporate, incorporated by any act for the time being in force, as the central government may, by notification, specify in this behalf, subject to such exceptions, modifications or adaptation, as may be specified in the notification. Companies Act, 2013 is not applicable to unincorporated companies. An unincorporated company, association or partnership consisting of large number of persons has been declared illegal. By virtue of Section 464 of the Companies Act, 2013, no association or partnership consisting of more than such number of persons as may be prescribed shall be formed for the purpose of carrying on any business that has for its object the acquisition of gain by the association or partnership or by the individual members thereof, unless it is registered as a company under this Act or is formed under any other law for the time being in force. Rule 10 of Companies, Miscellaneous Rules, 2014 prescribes 50 persons in this regard. The maximum number of persons which may be prescribed under this section shall not exceed 100. Section 464 of the Act does not apply to the case of a Hindu undivided family, carrying on any business whatever may be the number of its members. However, this section is also not applicable to an association or partnership, if it is formed by professionals who are governed by special acts. Key concepts. The 2013 Act has introduced several new concepts, and has also tried to streamline many of the requirements by introducing new definitions. Some of the concepts are discussed here in brief. 1. Companies 1.11 person company. The 2013 Act introduces a new type of entity to the existing list, i.e. apart from forming a public or private limited company, the Act enables the formation of a new entity, a one-person company, OPC. An OPC means a company with only one person as its member. Section 3, 1. 2. Private company. The 2013 Act introduces a change in the definition for a private company. Inter alia, the new requirement increases the limit of the number of members from 50 to 200. Section 2, 68. 1. 3. Small company. A small company has been defined as a company, other than a public company. I. Paid up share capital of which does not exceed 50 lakh rupees or such higher amount as may be prescribed, which shall not be more than 10 crore rupees. And 2. Turnover of which as per profit and loss account for the immediately preceding financial year does not exceed 2 crore rupees or such higher amount as may be prescribed, which shall not be more than 100 crore rupees, provided that nothing in this clause shall apply to A. A holding company or a subsidiary company. B. A company registered under Section 8, or C. A company or body corporate governed by any special act. Section 2, 85. 1. For dormant company, a company formed and registered under this 2013 for a future project, or to hold an asset or intellectual property, and has no significant accounting transactions. Such a company, or an inactive company, may make an application to the registrar for obtaining the status of a dormant company. Section 455, 1.5 Nidhi company. Nidhi company means a company which has been incorporated as a nidhi with the object of cultivating the habit of thrift and savings amongst its members, receiving deposits from and lending to its members only, for their mutual benefit, and which complies with such rules as are prescribed by the central government for regulation of such class of companies. Section 406, 2. Roles and responsibilities. 2.1 Officer. The definition of officer has been extended to include promoters and key managerial personnel. Section 2, 59. 2. To key managerial personnel. The term key managerial personnel has been defined in the Act, which means I. The chief executive officer or the managing director or the manager. 2. The company secretary. 3. The whole-time director. I. The chief financial officer. V. Such other officer, not more than one level below other directors, who is in whole-time employment, designated as key managerial personnel by the board, and V. Such other officer as may be prescribed. Section 2, 51. The role and liability have been defined at various places under the Act. 2. 3. Promoter. The term promoter means a person A. who has been named as such in a prospectus or is identified by the company in the annual return, or B. who has control over the affairs of the company, directly or indirectly, whether as a shareholder, director or otherwise, or C. in accordance with whose advice, directions or instructions the board of directors of the company is accustomed to act, provided that nothing in subclause C. shall apply to a person who is acting merely in a professional capacity. Section 2, 69. 2.4 Independent Director. The term independent director has been defined in the Act, along with several new requirements relating to their appointment, role and responsibilities. Further, some of these requirements are not in line with the corresponding requirements under the Equity Listing Agreement. Section 2, 47, 149. 5. 3. Audit and auditors. 3.1 Mandatory auditor rotation and joint auditors. The Act mandates the rotation of auditors after the specified time period. Section 139. 3. 2. Secretarial audit. The Act mandates secretarial audit for the following: A. Listed companies. B. Every public company having a paid-up share capital of 50 crore rupees or more. C. Every public company having a turnover of 250 crore rupees or more. The Secretarial Audit Report is required to be annexed to the Board's Report. Sec 204, 3.3 Secretarial Standards. The Act requires every company to observe secretarial standards specified by the Institute of Company Secretaries of India with respect to general and board meetings. Section 118, 10. 4. Corporate Social Responsibility. The Act introduces the culture of corporate social responsibility, CSR, in Indian corporates by requiring companies to formulate a corporate social responsibility policy and at least incur a given minimum expenditure on social activities. 5. Class action suits. The Act introduces a new concept of class action suits which can be initiated by shareholders against the company and auditors. Formation and incorporation of companies. Section 3, 1, states that a company may be formed for any lawful purpose by A. 7 or more persons, where the company to be formed is to be a public company. B. 2 or more persons, where the company to be formed is to be a private company. Or C. 1 person, where the company to be formed is to be one-person company, that is to say, a private company by subscribing their names or his name to a memorandum and complying with the requirements of this Act in respect of registration. A company formed under Section 3, 1, may be either A company limited by shares, or B. A company limited by guarantee, or C. An unlimited company. Section 7, 1, of the Act provides for the detailed procedure for incorporation of company. Note, for details on types of companies and formation of companies you may refer paper 3 of module 1, i.e., setting up of business entities and closure, lesson roundup. The word company is derived from the Latin word com equals with or together, pinus equals bread, and it originally referred to an association of persons who took their meals together. The main characteristics of a company are corporate personality, limited liability, perpetual succession, separate property, transferability of shares, capacity to sue and be sued, contractual rights, limitation of action, separate management, termination of existence, etc. The company, though a legal person, is not a citizen under the Citizenship Act, 1955, or the Constitution of India, though it has established through judicial decisions that a company cannot be a citizen. Yet it has nationality, domicile and residence. In India after independence, the Companies Act, 1956 was enacted with a view to consolidate and amend the earlier laws relating to companies and certain other associations. The Companies Act, 2013 has replaced the Companies Act, 1956. Further, the Act has been amended 4 times. Where a fraudulent and dishonest use is made of the legal entity, the individuals concerned will not be allowed to take shelter behind the corporate personality. The court may break through the corporate shell and apply the principle of what is known as lifting of or piercing the corporate veil. Jurisprudence Ordinance Glossary. The study of law and the principles on which law is based. Ordinances are temporary laws that are promulgated by the President of India on the recommendation of Constitution of India. Provide for the Union Cabinet. Article 123 of Power of President to promulgate ordinances during recess of Parliament. They enable the government to take immediate legislative action. Ordinances cease to operate either if Parliament does not approve of them within 6 weeks of reassembly, or if disapproving resolutions are passed by both houses. It is also compulsory for a session of Parliament to be held within 6 months of passing an ordinance. A bill is proposed legislation under consideration by legislature. A bill does not become law until it is passed by the legislature. Once a bill has been enacted into law, it is called an act of the legislature, or a statute.